Welcome to class 5 of our EMW Gen Next classroom series. Today, we have an important chapter regarding mediation. And I myself, Rajesh Das, advocate. I practice in the line of civil as well as in criminal cases. And I am also a mediator come trainer of MCPC. And today's student moderator is Sanjeev Rao. And I request Sanjeev to remind all of us about the ground tools and other queries if you have any got. Sanjeev, over to you.
Thank you, sir. A very warm and good evening to everyone who have joined in. I am A. Sanjeev Rao, first year law student of MS University at Vadodara, Gujarat. And I am the student moderator for today's session. I am thankful to EMW team for arranging these wonderful, enlightening sessions on mediation. Today, we have gathered in for another beautiful Saturday evening for today's EMW class on concepts and elements of mediation. Doubtless to say, I am sure that the knowledge shared by our mediators will be thought-provoking and insightful as always. I would like to extend my gratitude to Mr. Rajesh Dasar and Ms. Reema Bhandari ma'am, who have taken out time from their busy schedules to come and teach us this evening. Furthermore, I am extremely grateful to Pushpa Gupta ma'am, Tan Kachan sir, for giving us this opportunity and the entire team of EMW for bringing such proficient dignitaries and legal professionals to ensure that we gain the best mediation and ADR from this classroom series. Moving forward, I am sure every one of us is familiar with the ground rules to keep their microphones turned off throughout the session, just to avoid any kind of disturbances during the learning process, and to keep your cameras on during whole class as it generates respect and attentiveness. And in case of any doubts or questions, you may put them in a chat box or wait till the session is over, and the mediators are open for question and answers. You can also email me the questions, which I will surely pass on to the teacher. We are looking forward to great learning experience. So without any further delay, let's begin. Thanks for the opportunity. Over to you, sir.
Thank you, Rajiv. Today's our topic is concept and elements of mediation. And our speaker teacher is Ma'am Reema Bhandari. Ma'am Reema Bhandari is an advocate as well as a mediator and a trainer. She practiced in Supreme Court, Punjab High Court, Punjab and Haryana High Court, and is also one of the accredited trainer of the Mediation and Conciliation Project Committee of Supreme Court of India. Ma'am is a seasoned litigator and a mediator with more than 25 years of experience in litigation and over a decade's experience in mediation. Reema ma'am is associated with mediation since its inception or its use in India sometime in the year 2007 as an alternative dispute mechanism. She has successfully settled more than thousands of disputes through the process of mediations, mostly heavy and contentious disputes referred by the honorable courts. And as a trainer, she has been conducting mediation trainings programs all over India for advocates, judicial officers, and others under the aegis of MCPC. In addition to her role as a litigator and mediator, ma'am is also involved in various teaching groups. She is conducted awareness programs for clients on complex of cyber law related issues. And with her experience, she is also one of the visiting faculty to various law college and reputed institutes like Campus Law Center, Delhi University, Amity Law School. She is also one of the resource person in State Judicial Academy and state legal authorities. She, she periodically conduct training program amongst other on cyber law and various laws for judiciary as well as police and advocates. I am glad enough to meet her class, even attended a class conducted by her sometime in 30th August 2021 at Ranchi. I will not take much more time as all of us are eager to hear ma'am. Ma'am, the floor is yours. And even we are interested to have some new ideas about concept and elements of mediation. Thank you.
Okay. So first of all, I would say thanks to Rajesh and Sanjeev for the wonderful introduction. And Rajesh, I am not ma'am for you. We are friends. Why calling me so formally here? We are good friends, buddies. And I want to say, Sanjeev, no need to be thankful for taking out time and all. We all love to do it. In EMW, I would say I can vouch upon the team of EMW that we all love to be associated with any kind of training or imparting some education to the coming generation on mediation. So we all love to do it. So rather, we are thankful that we are having this platform and having you guys and that we can share our knowledge and experience with all of you. So as you all know that we have come out with a book called Mediation Compendium, and in which I have written also a chapter on this particular topic itself. So some of mostly what I'm going to speak today right now is from my book, from the chapter on this book itself. And so I would request if you like it, then all of us should have one copy of that book with ourselves. So let's start our this thing. Let me just give me a minute to set my screen for a minute.
Yes.
Yeah. So, am I audible to
Yes.
everyone properly?
Yes, you are audible.
Great. So, so in continuation, I would say on the last few classes we already had in our this series, and I feel you all must have learned why mediation is preferred as a mode of ADR and various traditional practices of mediation in our country. What is conflict management and understanding the restorative justice facet of mediation process. Today we will delve into the concept and elements of mediation. So to do that, as you can see on my screen, the definition of mediation. So let's look at this definition and understand for the better understanding, I would love to divide this definition into three parts. So the first part comprises of three basic components of mediation, that it is voluntary, party-centered, confidential, and structured negotiation process. So let's discuss in short this first part itself. So Voluntary, which means consent of parties, is supreme. Party centers means parties are focal points. Definitely confidentiality. We will be doing all of these, elements in detail in our class today. And it's a structured negotiation process. So there is a structure. There are four stages in the mediation process, which I am not going to touch today because in our coming classes we will be, having a full class on these four stages of mediation. Then the second part of the definition is, I would say, it talks about the fourth component of mediation, which is neutrality, and the role played by the mediator in the process of mediation. So neutrality is intertwined with the role of mediator. He acts like a cement, I would say, which holds all the components together and plays the role of a facilitator and refrain himself from playing a role of an advocate or a counselor or a judge. Then the third part of the definition talks about the various communication skills and negotiation techniques used by the mediator. I am not going to touch the third part of this definition because we will be having separate classes on the communication skills as well as on the negotiation skills. Since it's our first class on mediation per se, what is mediation, what are the basic elements of this mediation, so it is important for you to understand what all is a part of these classes, is going to be the part of these classes. So now I would say let's start understanding the various concepts and elements which I just read from this definition. Oh my God, it's not sharing. Just give me a minute. So the first element which we are going to discuss right now is confidentiality. So confidentiality, what is confidentiality? In normal life, in ordinary life, don't know. But as per Oxford Dictionary, it defines it as entrusting one secret to another. But in mediation, it is better understood and explained in terms of a duty or an obligation owned by the mediator and the parties to refrain from disclosing any information, from disclosing any information provided in connection with the mediation. So I would say that way confidentiality is an inherent part of the mediation process. I don't know why my slideshow is not running properly. Again, it's getting stuck.
You can press the down arrow key. You can press the down arrow key.
That's what I'm doing, Kanchanji, but every time when I'm using, it's getting stuck.
Yes.
Okay. So, as you can see on the screen, confidentiality, I would say, of mediation communication is extremely broad and covers whatever is discussed during the mediation process between the parties and between the parties as well as the mediator. So, and confidentiality is ensured not only during the process of mediation, but also in case of non-resolution of dispute by the parties. So even if the matter is not settled, confidentiality of what has happened in the mediation is given utmost importance. This way, it has two dimensions. The first dimension is, or rather, I would say the first dimension takes care of the information exchange between the parties and the mediator vis-a-vis the third parties who are not present in the mediation. It means especially, I would say, in the court and its mediation, in case the matter is not settled and the mediator cannot mention in that case in its report the reasons of its not being successful, or mention the various proposals exchanged between the parties, or his own opinion about the whole dispute. He is barred by the legislative provisions as well as various judgments passed by the honorable courts from time to time. We will be discussing those shortly. The second dimension of confidentiality is with regard to the separate sessions taken by the mediator. In the separate sessions, he emphasizes, he assures that whatever the parties disclose to him during the session will not be disclosed to the other side unless it is permitted by the party who is sharing the information. This means the information shared between the party and the mediator in the separate session remains confidential between that person who is there in the separate session and the mediator. So the mediator mentions about this particular rule to the parties while giving his opening statement in the beginning of the mediation and also before conducting separate sessions with the parties. So though I already said that we will be having a separate class on the 4 stages of mediation, but to have a better understanding, I just want to tell that there are, because I will be talking about these stages in between my class also today. So the first is the opening statement and introduction, where the mediator introduced himself and the parties introduced themselves to him, and at that stage itself, the mediator, I would say, tells some ground rules to the parties about the basic elements in short to the parties. So this is the first stage, how it is done, how much time it is taken by the mediator to do all those things will be done in detail in the other class. Then the second stages of joint session, and third is the separate session. The joint session, both the parties are there, and the separate session, one party is speaking separately with the mediator. So in that confidentiality I am talking about in the second dimension here, that whenever they are talking in confidential separate session, then that confidentiality in that particular session is also maintained. So these are the 2 dimensions of now coming to, just a minute, I'm not skipping anything. Okay, so mediator role is very important here. So that is why I was explaining what is opening statement. So opening statement of a mediator plays a very important role of setting the stage before mediation begins. So in the opening statement, while explaining about the process of mediation, its basic elements, the do's and don'ts, the guidelines, he especially informed the parties about his role with regard to the confidentiality, especially here. It tells the party that he is duty bound not to disclose any information, documents, proposals shared by them in the joint as well as in the separate sessions. Secondly, he cannot testify, that is, he cannot give evidence before any court of law or tribunal with regard to the documents seen by him or the statements or any admissions made by the parties during the process of mediation. He can never act as an attorney for any of the parties, because after acting as a mediator, when he knows all the sensitive and secret information of both the parties, that will impact his neutrality. So he is actually totally prohibited to act as their counsel later on. Further, he makes the parties aware that the mediation rule do not allow any kind of publicity of what is happening in the mediation, or even if the settlement is made, then those papers are confidential between the parties, and only the agreement is sent to the court for the purposes of passing a decree on the basis of that particular agreement. And while we are doing a lot of mediation nowadays online, so it is important that he should always tell in the beginning itself that the video and audio recording of the mediation process is totally prohibited. And definitely he will also inform them at that time that even if they record, it is prohibited but it cannot be used by them later on as evidence in any court of law. So there is no use even if they record. So this is the role of the mediator to establish a confidentiality, and not only he has to say, he by his own acts during the whole process of mediation, he maintains confidentiality of both the parties. Now there are various legislative provisions, rules and judgments which enforce the confidentiality aspect of the mediation. Rule 9 of International Chamber of Commerce says that confidentiality is an essential feature of mediation. Parties who want to resolve the dispute are encouraged to speak freely. It also ensures privacy and confidentiality with regard to the submissions made by the parties. Further, Section 79 of the Arbitration and Conciliation Act, in accordance with ancestral model law, states that mediators, conciliators, and parties should keep confidential all the issues discussed during the mediation proceedings. Section 80B of the Act prohibits the conciliator to be present as witness in any arbitral or judicial proceedings, and Section 81 of the Act also stops the parties to rely upon the views expressed by them or by the mediator as an evidence in any arbitral or judicial proceedings. Now, the Honorable Supreme Court in Moti Ram and another versus Ashok Kumar case held that the mediation proceedings are confidential in nature, and in this case, Supreme Court actually has referred a matter for mediation to the Punjab and Haryana High Court. And when the report was sent by that mediator to the court, by mistake, also cited the reasons for the mediation being unsuccessful. So the Honorable Court in this case held that the whatever is discussed between the parties, it stays with the parties, it stays with the mediator and parties in the mediation only. So in case the court held very strictly that if the matter is settled, the mediator is only supposed to send the executed agreement between the parties to the court, and in case the matter is not settled, then on the report normally ordinary only says that the mediation failed or the matter is not fit for settled, mediation was unsuccessful, nothing beyond that. So this judgment, I would say, has taken a step ahead in relation to the court-directed mediation and asserts that such mediation proceedings are confidential in nature. Then the second case is Salem Advocate Bar Association versus Union of India. Now, it's a very detailed case. If you want, you can, later on, Axon judgment, Salem Bar, they are very, I would say they are Bible on mediation, but I am just telling you that part of the judgment which is connected with the confidentiality. So, in this case, actually, the court has asked the various high courts of our country to make mediation and conciliation rules. And these mediation and conciliation rules are prepared by all the high courts, more or less by all the high courts, and are applicable to those high courts and the district courts which are working under those particular high courts. So today I will be talking or I will be having the slides on those mediation rules. So I am, because in Delhi, so I will be talking about the mediation and conciliation rules which are made by Delhi High Court in 2004, but more or less all the high courts are similar kind of rules. Then another very interesting case is Rama Agarwal versus State Legal Service Authority. Now, in a case before this, this case was before Central Information Commission, and in that case it was held that parties cannot seek information pertaining to mediation proceedings under the RTI Act 2005 as the case falls under the provisions of the said Act. as the case falls under those provisions of the Act which talks about the exemptions. So it was held that parties cannot seek the information with regard to the mediation, conciliation or counseling, because that it will impact the, I would say, the growth of the mediation process in the country. So these are few important judgments. I will be just coming to the rules now. Rule 20. Now these mediation and conciliation rules of Delhi High Court are applicable to Delhi and as well as all the district courts in Delhi. Rule 20A lays down that information shall be kept confidential and can only be disclosed after obtaining consent from the party which has disclosed said information. It means that the information which is shared between the parties and the mediator in the separate session, then only the mediator, after asking the parties, after the end of the separate session, mediator will ask the party that whether can I share this information, and only if the parties give consent to this, you can, to this extent only you can tell them. So in that case only that, to that extent only the mediator can share the information with the other side. Then the Rule 20 clause B, it stops the mediator from disclosing before any authority, tribunal or court the documents pursued by him in his capacity as a mediator. Rule 20C endorses confidentiality with regard to the views expressed by the parties, documents obtained during the mediation, proposals made or views expressed by the mediator. Clause B prohibits audio or video recordings of the mediation proceedings. Rule 23, it deals with the communication between the mediator and the court. So it restricts the communication only to the extent it is necessary for the mediator to inform the court about the settlement of the case, one, or non-settlement of the case, or at times the presence or non-presence of the parties. Because when the matter is sent back, normally we write, when we prepare our sheet, we write who was present and who was not present. Beyond that, no communication between the mediator and the court which has sent the matter to the mediation center. Rule 27, it lays down the ethical principles to be maintained by the mediator. Clause S says that it is a duty of the mediator to be faithful to the relationship of the trust and confidentiality imposed in his office. So I just want that you should know that when we are saying that these are the basic components of mediation, till our new act comes into force, we are governed by these mediation and conciliation rules, these judgments, section 89 of CPC. We will be doing all these things definitely in our other classes in detail. Now, the significance. Confidentiality, I would say, is significant as it allows the party to disclose the information without the information coming into the public eye. It allows them to express freely, communicate effectively, collaborate to resolve, and they can actually engage themselves in an open dialogue without any fear. Thus, it is one of the key reasons I say that by parties choose and prefer mediation as a form of ADR over other kinds of ADR. Maybe I think you know that there are 5 types of ADR and mediation is one of them. So because of this confidentiality part, the parties choose or they prefer to choose mediation over other type of ADR. Secondly, confidentiality leads to trust building between the parties and the mediator. They are able to share the sensitive information so that mediator can understand what are they looking for, what are their underlying interests. And during the course of mediation, the party actually not, I would say not on the first day they start trusting the mediator, as though it's not possible. So this trust actually it grows gradually from the first date to the second date to the third date, and it depends a lot upon the mediator that how he or she is expressing or demonstrating and keeping and maintaining the confidentiality of the parties when they are talking with them in the separate session and then coming back again in the joint session. Then confidentiality also, I would say, deprives the disputant's ability to misuse the information shared by them in the mediation due to the fact that such information used in the negotiations cannot become the part of court proceeding and cannot be used as evidence. So that is what I mean when I say the environment is secure, because there is no fear that somebody is judging me or somebody is going to report if I tell them that this is what I am looking for. So it is, so they feel so secure that even if it is not settled, I am quite safe. Because of that only they participate freely in the mediation. Confidentiality, as I said, it leads to effective communication. So effective communication means they are able to say whatever they feel like without any fear because of the secure environment. And in simple words, I would say that what is disclosed in mediation stays in mediation. That's it. So this quality of the mediation process facilitates disclosure of the sensitive information by the parties, as they will never disclose such information before any other authority, before any court of law, before in any arbitration or lok adalat. This is only and only in mediation. So this is, I would say, what is disclosed, it stays here, it will not. That is why mediation is done in a closed room where only the parties are sitting and the mediator are sitting, and that's how there are a lot of things are done by mediation centers. We have beautiful rooms so that confidentiality part is maintained, that one is, when one is speaking, there should not be other third party whom they do not want to hear. So this is what is the significance of confidentiality in mediation. Coming to our second component is voluntariness. So consent and willingness of the parties to join the mediation process, I would say, is one of the foundational building blocks that form the mediation structure. This is because from the get-go, the parties are not forced to enter into the mediation process and do so by their own volition. This has numerous benefits, which again I will be discussing. The process of mediation can only be initiated if the parties are willing to resolve their dispute, and the process continues and the process ends only and only with the consent of the parties. So they retain control over the outcome of the process. They can anytime refuse to divulge any information which they do not want to share. Mediator cannot force them to share their sensitive information also. They can even refuse to communicate at times when the matters are sent to us by the court. As the parties are not willing to join the mediation, we try to persuade them, that tell them the benefit of mediation and all, but definitely it's their wish. They can refuse not to say anything. And yes, the most important, that after discussions, after empty number of sessions, they can in the end always walk out without giving any reason that why they do not want to settle. So they are only bound when they sign the settlement, and when they and the mediator sign the settlement. Before that, they can change their proposals. They can refuse not to participate. They can say, okay, at the last minute. We have seen in a lot of cases, at the time when we are giving the dictations, only on at times even for the change of a small word also, they say, no, we do not want this word to be there. At the other side doesn't agree. They say, okay, no, we do not want to enter into an agreement. Now, here I just want to say one more thing, that this element of voluntariness is a point of discussion, I would say, in case of mandatory mediation. For example, Commercial Court Act 2015 provides that a suit shall not be instituted unless pre-litigation mediation is exhausted by the parties. So therefore, making pre-litigation mediation mandatory unless urgent relief is sought by the parties. Well, this kind of issue is also there in court annexed mediation, where the court suggests the parties to go for mediation, and the party says that, ma'am, we were appearing before the honorable judge and the court wants, so we have just come because we do not want to annoy the judge. So these are some point of discussions which are discussed in our I would say mediation family at various forums. But yes, I would like to say here is that in these cases also, voluntariness remains supreme, as parties can refuse to disclose information or participate in mediation, and mediator cannot disclose in its report the reason of failure of mediation. So even if the parties have come in the mediation, and if they are not voluntary, and if they are not participating, the matter will be unsuccessful. It will be sent back and it won't be saying that the parties were not voluntary. So it is actually about a procedure, but voluntariness remains an important, I would say, a component of the mediation process. Mediation and Consideration Rule 16, it clarifies that mediator facilitates the voluntary mediation process, assists parties, identify issues, reduce misunderstandings, and address options, and he has no power to act as a judge or impose his decision on the parties. Further, Rule 27, Clause J also imposes an ethical duty on the mediator to preserve the voluntariness and self-determination of the parties in the mediation process. Willingness to embrace the process, I would say, is the core reason disputants expressing their issues. Otherwise, no one likes to share their problems with unknown persons. We all know. We all want our things to keep it with ourselves. We do not want anybody to know our secrets. So there must be some reason when in mediation, when people come, they start trusting the mediator, they start talking with the mediator about their issues. They are only able to do so because of this particular element, that they are voluntarily entering there and they know that everything will remain confidential, and because of that they will get actually really engaged in the process of mediation. So definitely it incentivizes parties to give their best effort to resolve. Since they are coming voluntarily, they want to resolve, then the third connecting thing is that the rate of compliance will also be high. Why? Because they have chosen a process, they have participated honestly, wholeheartedly, and now they have raised a decision, they have reached an agreement which is best for them. Then the chances are very high that they will comply with the agreement reached due to their own honest efforts. Then about the third component of mediation is self-determination. Now, it is a very important fundamental principle of mediation. It refers to each person's ability to make their own choices, to manage their own lives, and it allows parties to feel that they have control over their choices and gives them the ownership of their conflict as well as the resolution. So, personal autonomy is the capacity, we all know, to decide for oneself and to take a course of action, and is a key factor of self-determination. One of the reasons why we say that the conflicts are unpleasant, why we do not like conflict, is that the parties feel that there is a loss of autonomy. They do not have any control over the situation and circumstances. They feel being stuck. Another kind of dispute resolution the decisions are taken by the judges or arbitrators. So a third person is taking a decision for them. But in mediation, I would say the beauty of mediation that it is, and it is one of the reasons why mediation is different from other kind of ADR is that here there is complete respect of autonomy of the people who are participating in the. So this preservation of personal autonomy makes the parties feel more inclined to participate and to interact in the mediation process. Now, this particular aspect of self-determination is there in all the stages of mediation, like participating in the process, that is voluntariness. They are coming with their own wish, from choosing a mediator, or I would say flexibility with regard to the stages of mediation. If they want, they can start mediation from the separate session itself. Then discussing various issues in the joint session, asking for separate session to divulge sensitive information, generating any kind of options they want to, and then choosing the options which is better, which is more suitable for them. And in the last, to agree or to disagree to the options they have generated. So from the beginning till the end, the parties are determining everything in the mediation process. Well, with the assistance of mediator and their attorney, parties are able to discuss and understand various issues. After understanding those issues and understanding the stand of the opposite side, after making assessments with regard to the alternatives which are available to them, then they can take as much time they want to think about those options, to evaluate them. They can take the opinion of any expert and then take the best decision for them without any pressure. So they are making all the free or sorry and informed choices. So parties play a significant participatory role directly and indirectly, coordinate with the other side as well as with the mediator, as they know that the ultimate power resides with them. Everybody likes to be powerful. In mediation, the parties feel that they are most important and they have all the. Who will not like it? Everybody would like it, I would say. So this leads to an active and direct participation of the parties, as in fact it is their dispute, their problem, and who can understand their problem better than anyone else. So the relevance of this principle is further highlighted with the fact that the mediator only plays the role of a facilitator and cannot impose his views on the parties. His role is merely of a catalyst who can take the offer back and forth, but he cannot give his own input, and decisions lie only with the parties. So this is what is self-determination of the parties. Coming to the mediator role. Now it is the utmost duty of the mediator to inform the party at the time of the opening statement when he meets and giving his introduction about his role in the process, where he informs them that they are the one who are going to take decisions. It is important for him to clarify this at the beginning of the process. Otherwise, people keep on asking for their opinion. It has happened many times. They said, Madam, aap jo bata do, we will do that only. You please give your suggestions. Or we trust you so much, whatever you will say, we will do that. So never, never, ever do that. You have to tell them in the beginning itself that that is not my role. I am only a facilitator. For me, both of you are equal. So mediator is actually the, I would say, the guardian of the right of self-determination of the parties. He encourages the parties in all the stages of mediation and promotes their autonomy by making them understand from the beginning itself that the decision stays with them. This gives the party the liberty and freedom to stay in the process or to quit, and the right continues till the till the mediation ends. Now, mediator also assists here when they are making informed choices. You will say how. So mediator assists by using various techniques about which we will be talking later on in our next classes. These techniques are like Bhatna, Vatna and Manatna. Bhatna is the best alternative available to the parties if the mediation fails. Vatna is the worst and Manatna is the most likely alternative. Now, these are the techniques you will learn later on, but these are the techniques used by the mediator, and in these, while using these techniques, he will not be giving any suggestion to the parties directly. He will be asking relevant questions from the parties, and then the parties are able to do the reality check that what option, which is there is good for them, or whether they should enter into an agreement or not, and then what are the better terms for them. So that is how he assists them indirectly in making the choices which are informed, which are they are aware, even if it is a wrong choice or a choice in which they are losing some bit, but they are getting something, but they should be aware, they should be involved in the whole process before taking any decision. And definitely mediator always remain calm and patient and refrain himself from inflicting his own wishes on the parties. So once you become a mediator, even if you are a bit arrogant and like that, the mediation will teach you to remain calm and quiet and be patient. Only then you will be able to actively listen the parties. So he never put any kind of pressure, as it is his duty only to assist and respect the autonomy of parties. It is very important again for a mediator to keep his values and perception on the side and refrain from expressing his own views so that it should not impact the right of self-determination of the parties in the process. Rule 17 of the mediation and conciliation rules lays down that the parties alone are responsible for their decisions. They should be made to understand that mediator only facilitates and he will not and he cannot impose any settlement. He is not allowed to give any assurance to the parties that mediation will result in settlement. He cannot say so. How can we tell the parties that you come and we will be able to resolve? We can say we try our best. We have to stay positive. Definitely it is there, but we cannot give any kind of guarantee to the parties. Then Rule 27, Clause J. It deals with the ethics of a mediator and recognize that mediation is based on the principle of self-determination, and the process relies upon the ability of the parties to reach a voluntary and disclosed agreement. So this element, I would say, makes mediation a distinctive principle grounded in cooperation and collaboration between the parties. It makes mediation distinctive from other types of ADR as well as litigation. In all other forums, the parties are not able to determine for themselves, and this decision is taken by the third person for their dispute. This makes, I would say, mediation unique, as best outcomes are the ones which are decisions taken by the parties who are involved in that particular dispute, as they have a clear view of their situation than anyone else. Definitely, when people are empowered to come up with their own solution, they will participate in the process wholeheartedly and would like to follow through, leading to a better and a more desirable agreement. In psychology, I would say it is an important concept which refers to each person's ability to make choices and balance their own life. And it also plays an important role in mental health and well-being and promotes the dignity of the parties. As mediation, I would say, includes liberal traditional values like consent, respect, autonomy, privacy, dignity, all that makes the outcome of the process more principled and legitimate, as they reflect legal and social order in an appropriate manner. And in the last, as all we know, that mediator is a neutral and impartial facilitator. The right of self-determination helps the mediator to stay in his role only and assist so that his impartiality, his neutrality is not in question. So if the party's self-determination is maintained, then mediation can remain neutral and impartial. Coming to the next important ingredient, I would say, of mediation is neutrality. Well, we know that it is a state of not supporting or helping either side in a conflict. And in mediation, neutrality achieves fairness. So it is one thing to define neutrality, but it is another thing to link it to the role of mediator, to link it to the benefits of mediation. So unique nature of mediation, I would say, can only be realized if mediator stays neutral and conduct the process, I would say, in an appropriate manner. So neutrality in mediation is definitely, I would say, connected with the status of mediator even before he accepts the role of a mediator in a particular case. He is duty bound to explain the parties in the beginning at the time of opening statement itself. That is why I'm saying opening statement is very important. He has to address all these things in the opening statement itself. So he has to explain at that time that he is duty bound to explain that he has no knowledge about the dispute. So he has to tell the parties that I am neutral. And how will he tell? Then he will tell the parties that he has no prior knowledge of the dispute. Then second, he has to tell the parties that he has no acquaintance, he doesn't know any of the parties who are participating in the dispute. Now what happens at times, when the parties are there, especially in court and mediation, we see, they are coming with their lawyers. At times, the lawyers, when they enter our room, they are our friends. So they say, oh, very good. Oh, the matter is with you. I trust you so much. But though he is giving a compliment, but the other side might think that you might not remain neutral because one of the lawyer is your friend. So you have to tell the parties that yes, definitely, we all are lawyers, we know each other, but definitely it is not going to impact my neutrality. For this, I would say, I will just give an example of a case I was handling in Supreme Court Mediation Center, where both the parties, after giving the introduction, were sitting with me in the introduction, in the joint session, where I could, feel that I know one of the parties and the female very well, and or I have seen her somewhere, but I was not able to recollect that where I have seen, getting old, so all these things are happening with us also. So, but I was in a dilemma whether to start the mediation or not, because I was having, this thing was in my head. So I asked this lady that, please tell ma'am that do I know you? Because I feel I've seen you somewhere and I have talked with you also at one point of time in my life. So this lady smiled and she said, ma'am, few years back, for this matter only, I came to you for a consultation. And that she said in front of the husband only. So I immediately asked the husband that I do not remember the case because it came many years back. But yes, she came to me. Now you tell me whether you want me to act in this case as your mediator or not. So I was duty bound to do so. But yes, on the other hand, I was able to attain the, I would say, the trust of the husband more. He liked it so much that he felt that I was very honest. So he said, no, madam, rather I would now like that as this mediation should be done by you only as a mediator. So while doing so, what happened? I did not only my ethical duty properly, but I was able to win the trust of the parties by doing so. So it is very important. That is why I would say to establish neutrality from the beginning itself. And neutrality is something associated before a mediator starts acting as a mediator in a particular case. That he has no knowledge about the case, he doesn't know the parties very well. But this continues even after he starts acting as a mediator in a particular case. So the how he does so, that he will not support any of the sides by giving any suggestions in the process, as he is not supposed to give suggestions, especially for the benefit of one party and the cost of the other, because that way it will impact the neutrality of the mediator. And lastly, I would say it is very important the mediator should not have any interest in the process. He should not have any personal gains, as in that case he will become biased and can persuade the parties to take a decision which will help in getting those gains. So the next slide is the role of mediator. So mediator fulfill his duty to stay as neutral by ensuring that he has no interest in the dispute in the beginning itself, as I already told, and by saying that he has no acquaintance with the parties. But it is important for him to keep on maintaining a healthy distance with the parties while conducting the mediation later on also. That is why the mediation center, or where we all are working, whether it's Supreme Court or Karkaruma Court, they do not give the parties our contact numbers. It is important for a mediator to remain bit formal with the parties. You have to win their trust. You have to be there, actively listening for them, but you have to maintain a distance with them also. So that is why they do not have our contact numbers. So they can only be in touch with us during the mediation process only. At times we offer them tea and coffee, they are sitting with us, but that doesn't mean that I am becoming informal with them. Because if you become very close with one person, the other side will start, thinking that you are having some special corner for the other side. So they do not offer potential solutions favorable to one side. They do not develop interest in the issues during mediation. Like at times what happens when the parties are coming for a longer time, we start getting emotionally, not emotionally attached, I would say we start sympathizing with them rather. And in mediation, we are not supposed to sympathize. We are supposed to empathize. Now there's a difference between the two. We will be definitely doing all these things in our communication skills, so I'm not getting into that. And you all know the difference between the empathy and sympathy, so there's a bleak line. So he allows on parties to negotiate without any hindrance. So when the parties are discussing, he is there to maintain the process, but he should never stop the parties, or he should not himself become an element of hindrance. Because when parties are talking, it's their dispute, they can, I think, do a lot of out-of-box thinking and continue in generating options. So, and the last, I would say, neutral reframing. Yes. So, mediator remains neutral also by reframing the situation from a very different angle, because he is not attached with anyone. So he will look at the situation from a different angle. So that way he will reframe it in such a way that parties can, show willingness to find solutions. If the problem, I would say, is reframed by the mediator in a neutral manner, only then the parties can check their internal benchmarks, because the problem is presented in a different manner by a different person. So here the messenger as well as the message plays an important role to change the mindset of the parties. So neutrality establishes fairness and integrity, not only, I would say, in the process of mediation as well as in the office of the mediator. As the concept of neutrality is intertwined with the role of mediator, so we cannot separate them. So mediator is a caretaker of all these elements while conducting the process of mediation. Mediator is able to take a holistic view of the problem as he is able to understand the issue from various angles and perspectives, as there is a discussion that generates a resolution for everyone. And only a neutral mediator is able to build the trust, the credibility, and get respect from the parties. Parties can only respect him if they feel that he doesn't have any interest of his own in the outcome of the mediation. And definitely it impacts the quality of the outcome, as an open dialogue can be generated in the presence of only a neutral person. Parties will, let's suppose if I'm appearing in a court and if I feel that the judge is biased, is not neutral, I will definitely not appear in that court. I would like to get my case transferred. So that is how the quality of the outcome is impacted by the neutrality of the mediator. And last but not the least, neutrality paves way for pure procedural justice where all parties accept the outcome, which helps us ascertain that mediation is a part of a justice process. What is the time? Where I'm okay. So impartiality. Impartiality is normally the terms, I would say, impartiality and neutrality are used interchangeably, but in mediation, it refers to the management of the process by the mediator. Neutrality, along with impartiality, comprises the foundation of mediation process. So impartiality, as I already said, it refers to the management of the process of mediation. Neutrality starts before he starts acting as a mediator. Impartiality continues during the whole process of mediation. So that is the only bleak line of difference between impartiality and neutrality of the mediator. So mediator strives to be equidistant between the parties by giving them equal opportunity to express their grievances, so they feel that no one is the favorite of mediator. As we often hear from the parties, when they say so, you feel bad also that, ma'am, you are giving, you heard that party for 15 minutes and you gave me less time. So it is very important that impartiality should reflect in our behavior. It refers to an even-handedness and on the principle that decision ought to be based on objective criteria and not on the basis of biases and prejudices. And now, neutrality, along with impartiality, I would say, is to be reflected in the mediator actions, his behavior, his body language. He has no favorites. He treats all of them in the same way. He neither takes one person's side. He cannot exclude anyone just because of some characteristics or because of his own beliefs or on his own values. So it is important that a mediator should avoid any conduct which gives the appearance of partiality. It is important, and how does he do so? We will be doing in detail, I would say again, while we will be doing the communication skills, that how he says, how he gives an, how his body language should be done, how he should be given an equal eye contact, his sitting arrangement should be like that, that his impartiality in it. It's another class, we will be talking about all these things in detail later on. So we all experience, I would say, implicit bias in our lives, which occurs, I would say, very involuntarily. And we unconsciously associate ourselves with some beliefs and attitudes towards an individual on certain aspects like race, color, sexual preferences, their socioeconomic background, and on and on. But it is important for a mediator to keep aside all his perceptions, his beliefs, and enters the mediation process with a neutral mindset. So, mediators, it is important when we know that it is ingredient in us to have some kind of biases. While one is acting as a mediator, he should recognize bias, his own prejudices, to remain impartial while communicating with the parties, while asking questions, while rephrasing positions or interests of the parties. So, how can he do so? He has to divide equal time between the parties to make them feel that no one is their favorite. In case he is giving more time to one party, then it is important for him to acknowledge in front of the other side, saying that yes, due to some reasons, I have given more time to this person. But for me, you both are equal. I am equally available for you. Rather, if you want, I can give you more time also, so that they are satisfied, because these small things, they make hell of a difference. He should show same level of deference to both the parties by giving equal opportunities with regard to choosing, the time. At times, this becomes an issue. If one party is saying, I will free at 2 o'clock, the other will definitely say that no, 2 o'clock, no, madam, I am free at only 4. Then you are stuck. So you have to here also show your impartiality by handling the situation in a manner so that no one feels that you are accommodating the other side more over the other. Then he is definitely, I would say it's very important that he should refrain himself from playing the role of a legal advisor. Their lawyers are there, their attorneys are there. He is not supposed to give any legal advice, because once you start giving legal advice, then you are getting prejudiced, you are getting involved yourself, and definitely you cannot act as a judge. It is party's decision. Mediation and Conciliation Rule 8. It imposes a duty on a mediator to disclose any circumstances which is like to give rise to reasonable doubt about the independence and impartiality of the mediator. Rule 27 clause F imposes, I would say, ethical duty on a mediator to disclose any interest or relationship which is likely to affect his impartiality. So, success of mediation depends upon the impartiality of mediator, as an impartial mediator can build trust between himself and the parties. And if the trust is built, parties are able to participate, then definitely they will be able to reach a legitimate and a principled decision. People normally disagree. I've seen in our life, we disagree. Why? Because we are different. We have different views. We think differently. So when we are in dispute, the disagreements tend to be often more. So only an impartial, neutral third party, that is the mediator, can transform these disagreements into an agreement. And this is the beauty of mediation. So these are actually what I have covered are the basic elements of mediation. But just very quickly, 2 more slides, that is flexibility. The process of mediation is very flexible. You can start from anywhere, from any stage. Then multiple issues can be decided, especially I would say you can bring anything from outside to settle the dispute in court and its mediation, especially when we are settling one matter, 4 connected matters are also settled, or at times some other property which is not part of the dispute is brought in. There's a camel story and all which we will be doing, but flexibility is there. Any empty number of relatives, friends, partisans who can also act as a mediator, because parties trust them from very long time, are welcome in the mediation process. There are no formal rules of evidence. Attorneys are not necessary, but definitely they are very important, and parties can consult experts. And the last I would like to say, future-oriented, yes, it preserves relationships, it brings positivity and amicable statements. Since there's a shortage of time, so I'm not going in detail on these. I would like to stop myself here so that we can start our question answer round with our students. Just let me stop my screen sharing. Oh, great. So, any questions?
Yes, ma'am. There is one question. May I read it for you? Am I audible, ma'am? There is one question.
You're audible. You're audible.
Okay. There is one question. Can a mediator meet one party after the official duty? Is this right? And should this meeting be in knowledge of other party? Ma'am, you are on mute.
Okay. So I would say a big no. Mediators should never meet any party alone without informing the other side. Separate session means when the separate meeting is happening, the other side knows that the mediator is meeting separately one side. So if mediator is meeting with A in a separate session, B knows that A and mediator is meeting. And then definitely B, if he wants, can also meet him. But in case, and you are talking about meeting after the mediation session is over, we do not even speak with them over the phone calls.
Ma'am, good evening, ma'am.
Yes, sir.
Ma'am, since it is a process of justice, you told that mediation is a process of justice. And finally, you informed that no mediator has a role to assume himself as a judge. Without assuming him judge, how he can execute the process of justice, ma'am? Is my doubt.
Okay. So process of justice is not that a judge is passing an order. Justice is when the both parties are satisfied and deciding for themselves and they are happy with the decisions. They went out everything and then they are able to reach us. So they are feeling happy. They have saved so many years in the court which they would have wasted if they would not have settled the case themselves. So that means that is what I mean to say when said that it is justice. It's a part of justice process. Justice is not always when someone else is passing an order or judgment on in my dispute.
Okay.
Okay. Yeah.
Other question is it possible to mediate in case of heinous crimes, especially crime?
No. So we have already have, I think, a class on this, but we will be discussing this in detail, but there are only very few, cases. Otherwise, mediation is normally done in civil cases, but criminal cases where, the offenses are not very grave. Only those kind of cases can be handled in mediation, which are, compoundable with after paying of some small amount of fee and all. But otherwise, in all criminal matters, as per EFCON judgments and other judgments, definitely then the decision has to come from the court.
Okay, there is one more question from Tanvi Oja. There are ADR competitions in law school. So in that, counsel has a role to play. So can you guide me on that? What is the role and responsibility of a counsel?
Role of a counsel in the mediation. So definitely very good question, ma'am. So we are actually planning also to conduct classes on that where we have to sensitize our lawyer friends before they go to the mediation, the kind of preparation they are supposed to do. So a lawyer first has to sit with his party and explain and discuss with them the pros and cons of settlement. That is what what kind of chances they are having, in the court to win, whether they are, and how much time it will take in the court. So these kind of planning is done between the lawyer and the party before they go to the mediation center. So the counsel definitely plays a very important role. But in mediation is more party centered. Let the parties speak more. If you are participating in a, I would say competition, then your role in the competition, now I'm talking in a way when you will be participating there, the main role will be of the party, but you will be sitting and the party will be always asking you for your suggestion when some kind of, option is generated or proposal is given from the other side. Then the party will discuss with you that whether it is good for them to say yes or no to that particular suggestion given by the other side.
Okay, there is one question from Akila, which is partly answered by you, ma'am. What cases cannot be mediated other than criminal cases?
So the cases where, some kind of interpretation is required from the honorable court, for example, constitutional law, we want some change in the law. So in mediation, you cannot do so. in mediation, actually, we can handle those cases where the parties can decide. Parties cannot lay down the law.
Okay,
So all, matrimonial cases, commercial matters, and your property disputes, these kind of cases that they can decide can be, but otherwise all constitutional matters, criminal matters, and where some important law has to be laid down, definitely they cannot be mediated.
Okay, there are a lot of questions flowing in, ma'am. One question from Mohammad Ashfaq. A party can have choice to choose one mediator and other party has to agree if he satisfies. But if the mediation is between two countries?
Countries. So basically, there are two things here. If we are talking about court annexed mediation, so in those court annexed mediation, we have a panel of mediator, and a mediator is appointed by the judge in charge of that particular case. If for any reason the party, they do not like a particular mediator, or if the mediator says that he is not the right person, or if the party does not like the mediator, then they can get the mediator changed. And in case of a private mediation, the parties can definitely choose whomsoever with their consent to act as their mediator.
Okay, thank you, ma'am. There is one more question from Ruchi. As a mediator, what would we do if fervently disagreed with a client's proposed solution, mutual way?
I'm sorry, I couldn't get the question. Can you just repeat?
I read it again. As a mediator, what would we do if we fervently disagreed with the client's proposed solutions? In the bracket.
No, we will remove the mediator.
May I request Ruchi to unmute yourself?
That person can unmute and ask the question. I think because the question is not framed properly, I think.
Ruchi, can you hear? Can you please unmute yourself?
Yes, sir. Yes, sir.
Yeah, hi.
Good evening, ma'am. मैम माय क्वेश्चन इज दैट कि इफ अगर कोई एक स्टेज ऐसी आती है एज अ मीडिएटर जिसमें दोनों म्यूचुअल जो क्लाइंट्स हैं अपनी पार्टीज हैं वो एक ऐसे डिसीजन पे पहुंचती हैं या ऐसा प्रपोजल रखती हैं जिससे हम ही खुद एग्री नहीं करते इन पर्सनल वे, देन हमें क्या करना है एज अ मीडिएटर?
तो रुचि, वेरी गुड क्वेश्चन, बट हमारा कोई रोल ही नहीं है एग्री और डिसएग्री करने का.
Yes, ma'am.
It is parties' decision, self-determination of the parties, as I was saying. Their problem, they are deciding. The role of a mediator is here to see that जो decision लिया जा रहा है, which is permissible in law, it should be according to law. Parties cannot decide कि मैं किसी का जाके murder कर देता हूँ. Then definitely that agreement cannot be. So the agreement has to be in the four corners of law, according to the rules of mediation. That's it. Apart from that, I am nobody to agree or disagree. If someone is settling a 10 lakh thing in 2 lakhs and there's a power imbalance, I cannot do much about it. It's their right. Self-determination is most important. So mediator का agreement और disagreement उतना relevant नहीं होता है.
मैम आई हैव वन मोर डाउट रिगार्डिंग दिस प्रॉब्लम. मैम अगर हम इवेल्युएट करते हैं किसी प्रॉब्लम को तो कहीं ना कहीं हमें भी उससे कहीं ना कहीं वो लॉस को रिलेट करना पड़ता है खुद से भी कि हाँ ठीक है ऐसा है सिचुएशन, देन हम इवेल्युएट करते हैं. तो मैम उस इवेल्युएशन में ये डिसएग्रीमेंट का पॉइंट अपन पे अफेक्ट नहीं करता है हम लोगों पे एज अ मीडिएटर, जो हम व्यूज रखे हैं आगे?
There are two kinds of mediation. One is facilitative and one is evaluative. Okay? The kind of mediation I am talking today or in our course which we are doing is a facilitative kind of mediation. But definitely mediator plays a very important role in while the parties are evaluating also. And that role is done in a very, I would say in a very simple manner by asking you relevant questions in such a way. Framing of questions is a very important thing. What question to be asked, in what way and how. So the question they ask in such a way that the parties, they have to look for that answer. Like for example, you cannot tell the parties that ये decision आप जो ले रहे हो ये ठीक नहीं है because आपके favor में judgment है. If you feel so, then you will say, आप घुमा के उनको बोलोगे कि what do you think, what will you get from the court, you know. So then at times I was doing a case just 2 days back only where I felt, you know, there was a lawyer appearing and it was a case with regard to the Muslim law, and there is some change in that law, but the lawyer was not aware. But as a mediator, I can't teach a lawyer in the mediation. Then definitely no lawyer will like me and they will not participate and they will tell the parties to get out. You know, this mediator is bad. So with very respectfully at the separate session, I spoke with him and I asked him to check the latest laws and I gave him a date. So there's a way to handle these kind of things which you learn by experience.
Yes, before we go to the next question, ma'am, I would like to remind the participant that Tankachan sir is posting, spontaneously all relevant laws. Somebody can always refer that. The next question is from Bajrang. Ma'am, can we say that the basic job of mediator do settle dispute through the compromised, but if there is so, then how compromised situation can be justice?
Okay, can just say. See, justice here, I'm sorry, I think you are misunderstanding. Justice doesn't mean always that. Can you please tell me one thing? When an order is given by a court, one side wins and one side loses. तो दूसरी साइड जो लूज करती है वो तो बोलती है जस्टिस नहीं मिला, और जो जीत जाती है उसको लगता है जस्टिस मिला. So it is a relative term. So when I am saying it's a part of justice process because यहाँ पे लोगों को जो मिला है वो अपनी खुशी से मिला है, उन्होंने खुद डिसाइड किया है, और जो खुद हम डिसीजन लेके अगर किसी चीज को करते हैं तो मेरी अपनी ऑटोनॉमी इतनी रिस्पेक्ट की गई है, मैंने डिस्कशंस इतनी किए, so I feel more at peace and I feel that yes, this is just. कोर्ट में भी क्या है, एक जो हारेगा वो तो बोलता है कि जज को कुछ नहीं आता था, लॉयर को भी कुछ नहीं आता था, जस्टिस मिला ही नहीं. That is what I want to say when I'm saying it's a part of process of justice.
Yes, I think we are right on time. If the last
what is
anybody? Yeah.
Yes, sir.
Yeah, ma'am, what is success rate in corporates between corporate principal and agents, ma'am, by mediation?
You want to know the success of mediation in the corporate sector?
Yeah, like between dealers and the manufacturers, there is a specific contract will be there in business contract will be available from day one.
So
So is
now
corporates prefer it?
जैसे arbitration agreement एक clause रहता है ना हर deal में.
Yes.
Now it is more or less I've seen, especially जब से लोगों को पता चला act भी आने वाला है, so there are clauses in the agreement that people will try for mediation first, and if mediation fails, then they will go for the arbitration. So the awareness is definitely coming, sir.
If we require any immediate mediation, then we have to come through the proper jurisdiction court, or directly we can get a mediator.
It is a private thing also. No? There are two types of mediation. It can be a private mediation also. So before even pre-litigation mediation, before even going, there are pre-litigation mediation centers in Delhi High Court we have also. So before even trying and going to the court, the parties themselves can go and talk among themselves. And if they are able to reach a decision, it is decided there itself. They are not even going to the court.
Okay. Right, immediately, I think we required some mediation center.
So
we have some of clients.
चाहे वो FICCI हो, इन सब में already panel of mediators है. So you can go and choose a mediator from there.
Yeah.
Yes. Anything else, sir? Any questions?
Ma'am, every dispute. Hello. Ma'am, every dispute have a right side and another wrong side. If a mediator know very well about the wrong side, how can he act in neutrality, ma'am?
Sir, if I understood your question properly, so mediator is no one to say who is right or wrong, sir. I am not a judge. I cannot say he is right or you are wrong. I have to stay very impartial and neutral. For me, both of them are on the same footing. And my personal opinion, biases doesn't matter over here. It is their decision. That is what is the role of mediator.
Okay, thank you.
Welcome. So, any other questions?
I think, ma'am.
Sanjeev,
I think, thank you, ma'am. I think we are done with the questions.
done with the questions? Great. So, thank you so much. कोई question और भी हो तो आप mail box में छोड़ दीजिएगा, हम बाद में जवाब दे देंगे. Is there any way to do that?
I will
Yeah.
take
Yes.
1 minute, ma'am.
Yeah.
First of all, on behalf of the, at last, on behalf of the EMW team, we are thankful to Reema ma'am, not again ma'am,
Not ma'am.
Bhandari,
Yeah.
for giving so details and explain quite nicely regarding the concept of mediation and about its elements. In fact, she started very well from the very beginning, from its definition. I would also request on behalf of our team that all of you should make by heart the definition of the mediation, so that it will be easier for all of you to understand the entire process. And I am also thankful to Push Madam and Thankachan sir to give me the opportunity to welcome all of you and to give thanks on behalf of team EMW to all of you.